So you work in overtime here in Alabama, and you've probably asked yourself the big question: does all that extra pay count towards my child support? It's one of the most common and frankly most confusing questions that parents face. So today, let's just dive right in and get you some clear answers.
In this quick explainer, we're going to walk through 5 key areas to give you the whole picture. We'll kick things off with the main question about overtime, then we'll really dig into the legal definition of income. After that, we'll look at the official forms, see how judges have ruled in actual cases, and then we'll wrap it all up with the most important takeaways for you. All right, let's jump into Section 1. We're going to tackle the question that is probably on your mind right now, and it's the very reason this whole process can feel so complicated. I mean, this is it, right? This is the bottom line question. You're putting in those extra hours, maybe giving up time with family and friends, and you just need to know how that's going to affect your finances and your obligations. So the short answer is, yeah, it often does. But listen, often is not the same as always, and that little difference is where all the details are hiding. To really understand why your overtime might count, we have to look at the single most important term in any child support case.
And that brings us right to Section 2. What in the world is gross income? Now, this isn't just some legal jargon. It is the absolute foundation of the entire child support calculation. How Alabama law defines this one term? Well, it's the key to everything.
Okay, so this is the official language straight from Alabama's Rule 32, and I want you to notice that key phrase, income from any source. That language is written to be incredibly broad on purpose. The law is designed to cast a really wide net, to capture all the potential money available to support a child. And you can see just how wide that net is right here. We're not just talking about your base salary. It can include bonuses, pensions, workers' comp, heck, even gifts and prizes. The court's main goal is to base the calculation on the total financial resources a parent actually has available. All right, on to Section 3. So, we know the definition of income is super broad, but how does the court turn that idea into a real dollar amount? Well, it all comes down to the official state forms. This right here, this is the crucial document, Form CS-41. Both parents have to fill this out, and it's not just a worksheet. It's a sworn statement, an affidavit. That means you have to disclose your entire financial picture. This is the exact spot where you list not just your salary, but all those other kinds of income we just talked about. Now look at this number. This is a real figure from a landmark case, Smith v. Smith. In that case, the father argued his income should be lower because of his base pay, but the court looked at his history, his long history of working overtime, and calculated his earning capacity at $2,995 a month. This is a perfect example of a court looking beyond just a base salary to the reality of what a parent is consistently earning. Which leads us perfectly into Section 4. The rules and the forms are one thing, but what happens when parents just don't agree? How judges have actually interpreted these rules in real-life courtrooms. That's what truly matters. So, here's the absolute heart of the matter. The debate isn't about whether you worked a few extra hours last week. What the court really wants to know is this: is your overtime a regular, reliable part of your income? Is it consistent and predictable, or is it just a random, one-time thing? That distinction, it's everything. And these two cases show that principle in action perfectly. In Smith v. Smith, the dad's overtime wasn't a fluke. It was a pattern stretching back 18 years, so the court called it substantial and continuing. Then, fast forward to Tatum v. Carell. In this one, a mother was getting overtime in pretty much every single pay period. The court said that was consistently received and that the first judge actually made a mistake by not including it. So you see, it applies to both the parent paying support and the parent receiving it. The key principle is consistency.
And here's the exact wording from that Smith ruling. The court spelled it out plain as day. If the overtime is sufficiently substantial and continuing, and importantly, you can accurately calculate it, then it counts. It's not about some one-off windfall. It's about a reliable stream of income.
And this quote from the Tatum case, it's just as powerful. The appeals court said the judge abused its discretion. Now that's really strong legal language. It basically means the judge made a major legal mistake by ignoring the mother's consistent overtime. This shows it's a rule that has to be followed, or the whole decision can get overturned.
Okay, I know that was a lot of legal detail. So let's get into our final section and just boil it all down. What are the key takeaways you really need to remember for your own situation?
So here's what you really need to remember. First, if your overtime is regular and predictable, you should expect it to be counted.
Second, if you worked on a single, really unusual project one time that's not likely to happen again, there's a good argument for it to be excluded. Third, and this is huge, you've got to be honest and totally accurate on that Form CS41. But the most important thing is that the specific facts of your job and your payment history are what will decide the outcome. Because every single case is unique, the absolute best thing you can do is get advice from a qualified attorney who can look at your specific circumstances.
At the end of the day, the question isn't just about what you earned last month, but what the court believes you can earn over the next year. And getting that calculation right is absolutely critical. So if you live in Alabama and you have questions about how these rules could impact your child support case, please give us a call at Bone Law Firm at 256-547-1005. We're here to help you get some clarity.